everyone, Virgo Triad here. We're going to move right into how important it is to know your rights and empower yourself with regards to your finances. One of the ways that you can do that is by making sure that those lingering questions that you have with regards to what banks and creditors can and cannot do if you're unable to pay a debt gets answered before you step into this big heap of emotional mess that happens even during a time where it is most unexpected, like a layoff or an illness. Knowing your rights up front are one of the things that's going to assist you in knowing the best direction to take and when to take those steps, some of them extreme and some of them fairly easy, in order to assist you in making sure that you don't suffer for any longer than is absolutely necessary when there is something that occurs. What can creditors do if you don't pay? I'm going to step into that right now, and I'm going to be going over several different types of contracts and several different compliance laws that the creditors and banks must follow and how they can affect you. Now, keep in mind that this is generalized information that encompasses all states. My next video, which is part 2 of this video, will explain to you exactly what limits each individual state in the United States has as far as statute of limitations, so on and so forth, so that you are in the know of those laws. One of the questions that seems to really cause a lot of anxiety in people that a lot of individuals are not aware of is that first you need to know that you cannot be thrown in jail in this country for not paying your debts, with the exception of back child support if you were actually able to pay it but just simply chose not to. And a creditor can't just take money from your bank account or grab your tax refund unless you owe back taxes or you've defaulted on a student loan. To collect a debt, the general rule is that most commercial creditors must first sue you and win a money judgment, a court award, against you. But there's a big exception to this rule. Creditors don't have to actually sue first if the debt is guaranteed by collateral. Common examples of that are a car loan where the car you bought is security or collateral for a loan, or of course a mortgage or home equity loan where the house itself was pledged as collateral at signing. Though in about half the states, a lender has to go to court before foreclosing. Because you may be up against some lenders with sophisticated financial knowledge and legal resources, it's really important for you to understand the legal status of each and every one of your debts and what each creditor's rights are for your particular state. Again, these are going to be a bit generalized, but pretty much encompass all of them. Debts and creditors fall into different types of legal categories, meaning that some of your creditors have more rights to collect and a bigger availability to negatively affect you and your business than others do. The two main categories of debts and creditors are secured and unsecured. Secured versus unsecured creditors. There's a huge difference between the two. A secured creditor is any creditor to whom you or your business has pledged collateral in exchange for a loan, line of credit, or purchase. Collateral might be business property such as inventory and equipment, or your own property, such as your house, car, or boat. There are also involuntary secured creditors, those who have filed a lien or a legal claim against your property because they have a judgment against you or you owe a tax debt. Either way, if you or the business can't pay back the debt, a secured creditor can repossess or foreclose on the secured property or order it to be sold in order to satisfy the debt. An unsecured creditor is one to whom no collateral has been pledged at all, and who hasn't actually filed a lien. Typically, unsecured debts include credit card charges and amounts your business owes for inventory, office supplies, furnishings, rent, and advertising, as well as what's owed for services such as maintenance, equipment, repair, or professional services. Secured debts, many businesses owe secured debts. Businesses typically pledge collateral for credit lines, and business owners often pledge their personal property for business debts. Let's take a look at how quickly lenders can call in on a foreclose on collateral which a secured debt is actually not paid. As you probably know, if you miss a car payment or two on your car loan, and as is typical, the loan was used to buy the car and is secured by the car, the lender has the legal right to physically repossess the car and sell it at auction in order to recover the money that you owe, plus the costs of the sale and the attorney's fees. To do this, the lender doesn't have to get permission or a court judgment. Under the terms of the contract that you signed with the lender, a repossession man can simply reclaim the lender's property, and in many states, the lender doesn't have to give you notice of the repossession. You will just wake up and find your car gone one day. When all is said and done, you will still owe the difference between what the lender sells the car for and what you owed on the loan, called a deficiency. Also, the repossession will appear on your credit report for 7 years. Cars are the most commonly repossessed type of property, but if you borrowed money to buy business equipment or machines and used the purchased equipment as security, the creditor will have the same repossession rights. Also, some department store credit cards provide that the creditor automatically takes a security interest in any of the property that you purchase with that card. So if you don't pay a bill, the creditor might try to repossess the property. However, because creditors must get a court order in order to enter your house or business, repossession of property other than vehicles is actually extremely rare. Similarly, with leased vehicles or business equipment, if you miss a lease payment, the leased property can usually be immediately reclaimed without a court order. If you have a mortgage or deed of trust on your house or an open home equity line of credit, you must make payments on time to keep the house. If you don't, the lender can and probably will foreclose on your house because it is collateral for your debt. But foreclosures are not as quick as vehicle repossessions. In half of the states, a lender has to go to court before foreclosing, and in the other half, advance notice is required from the lender. Similarly, if you pledge your house as collateral for a business loan or a line of credit and you default on that loan, the lender can foreclose on your house. In this situation, the lender must always file a foreclosure action in court, no matter what state you're in. To avoid having the lender foreclose, you must either repay the debt, or if the debt is more than your equity in the house, at least pay the lender that amount so that it no longer has a reason to foreclose. The foreclosure process works differently in different states. In some states, the lender must file a lawsuit to foreclose on a house, called judicial foreclosure. In others, it can foreclose on property without going to court, non-judicial foreclosure. A judicial foreclosure typically takes several months longer than a non-judicial foreclosure. Though in California, a non-judicial foreclosure can take a year or more, giving you time to save some money and, if necessary, find a new place to live. If you're behind on your mortgage, you might be able to negotiate a loan modification with your lender. For example, the lender might agree to add your missed payments to your loan balance to stretch out your loan over a longer period of time, or to convert an adjustable rate mortgage to a fixed rate one. Your other options are selling your home for less than you owe, called a short sale, returning the deed to the lender, called a deed in lieu of foreclosure, or refinancing through the Federal Housing Administration, the FHA, or the Homeowner Affordability and Stability Plan. For up-to-date information about your particular options, if you're facing foreclosure, there are many different foreclosure survival guides you can find just by searching in Google. Just to let everyone know, although this should always be a last case scenario, Filing for bankruptcy can delay foreclosure. When you file for bankruptcy, all creditors, including mortgage lenders, must cease collection activities and foreclosures. However, the lender can ask the bankruptcy court for permission to proceed with a foreclosure if you're behind on your payments. So a bankruptcy may delay a foreclosure only a couple of months. Unsecured creditors, such as credit card companies and most trade creditors, must first sue you and win a money judgment against you before they grab your income and property. This is true whether you are personally liable for the debt, as is the case for sole proprietors and partners, or because you sign a personal guarantee for your corporation or LLC, or whether only your corporation or LLC is liable for the debt. Typically, however, before seriously considering a lawsuit, a creditor will try to collect the debt for several months and then turn it over to a collection attorney or collection agency, which will restart the process. In some instances, the creditor will conclude that you don't have enough property that can easily be grabbed to pay off the judgment and won't even bother suing you. For instance, say your house is worth less than you owe on your mortgage, meaning that there is no equity in it for creditors to take. Also, suppose that your consignment shop has few business assets and is doing so poorly that you don't anticipate having more than a few dollars of steady income that the creditor could even grab by ordering the sheriff or marshal to take money from the business premises. Your creditors or any collection agency or attorney your debt is turned over to may not sue you because they know it's unlikely that they could collect the money judgment. That's called being judgment proof. Instead, the creditor may simply write off your debt and treat it as a deductible business loss for income tax purposes. Typically, in 5 or 6 years, depending on your state's statute of limitations, which we will be going over in the second part of this video, the debt will become legally uncollectible. Only in a few states, such as Kentucky, Louisiana, Ohio, and Rhode Island, have longer statute of limitations, up to 10 and even 15 years. However, you can expect to be sued if there is a significant money that you have that's at stake and you have valuable personal or business assets, or just business assets if your business is a corporation or LLC, or if the creditor expects you to acquire significant assets in the future. For instance, if you are a sole proprietor and have an advanced degree, your creditor might assume you'll eventually make a decent salary and will sue you now and wait for you to make some additional income, such as in the case with maybe a doctor. In many cases, in many states, a court judgment can be collected for at least 10 years after the judgment is made. What does a creditor think is worth suing for? Significant amount of cash or accounts receivable, valuable business equipment or property, and if you're personally liable for a debt, valuable personal assets such as jewelry, fine art, collectibles, antiques, motorcycles, expensive bicycles, boats, or a vacation house. Whatever your personal situation is when dealing with a creditor coming after you through lawsuit do not try to hide assets. Sometimes, out of desperation, a business owner tries to protect personal or business assets by giving them to friends and relatives or otherwise trying to hide them from creditors. Although few small business people have the knowledge necessary to move cash to an offshore bank account, many try to hide it in the name of a parent, child, co-worker, or friend. Do not do this. Creditors' attorneys are experienced in ferreting out such hidden assets, and in extreme cases, these tactics can even give rise to civil and criminal charges of fraud. This is the end of part 1. See part 2 for additional information pertaining to your states and more rights with regards to creditors and judgments.